Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to be covering Chapter 7, which includes crime scene evidence and experiments. Now, this chapter, I've got a lot of information, like in others, that I have to bring forward, so we're probably going to go a little bit over the normal 60 minutes, if you will, but I'll try my best to keep things within that 60 to maybe 70-minute time period. And there's a reason for it, because I want to make sure that you get some specific information that I want to kind of push out to you. Also, don't forget about the key terms at the beginning of each chapter and the discussion questions at the end of each chapter, because those are very, very helpful as it relates to your weekly quizzes and, of course, your chapter exams. So let's go ahead and jump right in. And I've posted a couple of things as we go through. Some we're going to look at and some we're not going to look at. But if you want to know about the FBI's crime laboratory, and what happens and what goes on in these different labs and the different parts, there's a link here that you can click on and it'll take you to that. So our featured case, so between 1985 and 2007, a number of prostitutes were killed in Los Angeles. And eventually, LAPD linked the cases together. Now, using DNA evidence, they eventually identified Lonnie Franklin as the killer. And at least 10 women, possibly more, were killed by Franklin. And as we look at this case, we're going to watch about a 7-minute video. And this needs to be part of the lecture, because I want you to watch it, because it brings forward some big issues, not just relating to DNA, but a certain way that they use that DNA in this case to catch a suspect. So let's go ahead and watch this, and then we'll kind of move forward.
Tonight with the war on crime and a new weapon already transforming investigative work. It's called familial DNA, and it allows investigators to trace suspects through the genetic fingerprints of family members. Police of California credit the technology for the arrest last week of a serial killer suspect in a case dating back a quarter century. For now, just 2 states permit the use of this science, but as David Wright reports, that soon may change.
He's accused of the most brutal crimes of molesting and murdering at least 10 victims over a 25-year period. But Lonnie David Franklin Jr. is now behind bars because authorities say DNA evidence ties him to the crime scenes. And for the first time ever in this country, the DNA sample that first led police to his doorstep wasn't his. It was his son's. Familial DNA, it's called. What?
It's called familial DNA because it is the DNA not of the ultimate suspect, but of a very, very close relative.
California and Colorado are the only states that allow familial DNA searches. The Grim Sleeper case is bound to change that.
This is a landmark case.
Lonnie David Franklin Jr. is now the poster suspect for the expansion of genetic crime fighting.
This will change the way policing is done in the United States.
Mr. Simpson, would you show your hands to the jury, please?
The LAPD has come a long way since the People versus O.J. Simpson 16 years ago. Back then, the botched handling of DNA evidence helped defense lawyers raise doubts about the blood tying Simpson to the murder scene. Simpson, of course, was acquitted. But the LAPD's DNA lab is now state-of-the-art. If my DNA ended up on that table, could I end up being a suspect?
In theory, that's possible.
Today, the LAPD gave us a tour of the facility where they made the crucial breakthrough in the Grim Sleeper case. Remember, the familial DNA search had led them to suspect Lonnie David Franklin, but they had no DNA sample of Franklin on file until last Monday, when a police stakeout finally paid off.
The detectives actually hand-carried the items in here.
And what was it?
A slice of pizza, I think a fork, there was a napkin. It was a total of I think, 8 different items that they submitted to us.
And that was enough?
It turned out to be enough, yes.
As any fan of the TV show CSI can tell you, the technology is morally neutral.
Gentlemen, that drop of blood was fresh when it hit the shirt.
But the potential applications raise enormous ethical issues.
The fact
he's caught the Grim Sleeper is great, unequivocally. But you can imagine lots of misuses of familial DNA.
At one extreme, there's the world imagined in the movie Gattaca.
In the not-too-distant future, our DNA will determine everything about us.
Where the genetic database determines everything from where you can work to who you can marry. That's science fiction. But as of the Grim Sleeper, it's now science fact that a DNA sample collected from one person can implicate members of an entire family.
There are certain families that are going to be looked at much more closely by the police than others. This raises specters that used to be associated with the eugenics movement, the science of better breeding. It's almost the idea of corruption of blood.
There's also the fear that DNA databases could be the ultimate in racial profiling.
African Americans are represented in DNA databases at a rate of about 4 to 1 to whites. That means that the families of African American people in the database are going to be disproportionately placed under permanent genetic surveillance. I imagine there are lots of African American families who will think that that's racial discrimination, pure and simple.
It's not a racial injustice when you catch somebody who just killed 10 people. The people who are most happy about it are the families of the victims, which are all African Americans.
Proponents of the expanded use of DNA point out it's not only helped implicate the guilty, it has also helped exonerate the innocent.
We are here today, Your Honor, because we are convinced that he is not guilty.
Thank you. Among them, Eddie Joe Lloyd, who served 17 years in a Michigan prison for a murder he didn't commit. But what about Lily Haskell of Oakland, arrested last year while attending a Bay Area protest of the Iraq War and forced to give a sample of her DNA? The very law that expanded California's DNA database, leading to the Grim Sleeper's arrest, requires that anyone arrested for a felony give a DNA sample, whether or not they're ever charged or convicted. In Haskell's case, the charges were dropped, but that DNA sample is still in the database.
Who knows what they're going to do with my DNA?
Haskell and others, backed by the American Civil Liberties Union, are now suing the state of California, hoping the expanded database will be declared unconstitutional. California Attorney General Jerry Brown will be defending the new law.
There is in our society a presumption of innocence. Does this in any way infringe on that?
No more than taking their fingerprints. I mean, you're arrested. The first thing in your book is you put your hand down and they get your fingerprints. That's a fact.
DNA reveals much more about me than my fingerprint. It may reveal my predisposition to diseases, my genetic history, and it's not at all clear that the full DNA fingerprint may not be stored in ways that will come back to haunt us.
What would be wrong with tossing that sample when the case is tossed out?
Why not give back fingerprints? Take them out of the FBI file once you're not arrested. We don't do that.
Do you understand why a lot of liberals are upset with you for taking it to you?
I don't know if they are. The DNA approach to California is reasonable. The people voted for it, and I'm hoping the courts will uphold it.
But right now, the strongest argument Jerry Brown can make in court is that without this technology, a suspected serial killer would still be out there, preying on innocent lives. I'm David Wright for Nightline in Los Angeles.
Okay, so hopefully that gives you a better idea regarding some of the things that we're going to talk about. Now, along with this, if you have any thoughts about DNA and things like that, you can look up the Maryland versus King case, because I know you all love looking up case law, and you'll see some pretty good information, specifically good towards law enforcement, if you will, that addresses some of the issues that were spoken about in this video. So take a look at that. And now we got to kind of like jump right into it. So in this case, Franklin was caught in part by testing the DNA, of his kid. And should a person's identity be tracked by using their family? And why did Franklin elude police for so long? And are the police and the public becoming too reliant on DNA to prove cases? And these are all just questions that can go through your mind. And I'm going to go past the Night Stalker case, but if you want to look at it at your own time, this is another really good case that deals with some witness ID and physical evidence that was recovered that ultimately brought the Night Stalker to justice. So I'm going to kind of go through that. So what are our learning objectives? Well, first to understand how chain of custody works, because this is really important, and we heard a little bit about that in a previous chapter. Explain how scientific tests and techniques are applied in court, and explain how, let's say, ballistics and DNA and fingerprints and blood types are useful, and describe common scientific tests, and explain how the foundation is laid for admissibility of tests. Because remember, in order to get things in, whatever it is, you have to have a witness testify about it. So if somebody analyzes blood in, let's say, a murder case, there's a good possibility they may have to go to court and testify about the test that was used, etc. So some myths. Most cases are solved by DNA. Well, that's not really true. DNA tests can only be done on certain things. And crime scene investigators solve most of the cases. Well, some are solved by DNA scientific tests, but in many cases, there are no tests that are performed. And the police can detain anyone who is a suspect and take DNA. Well, that's not true either. Fingerprints, mugshots can be taken in the field if there is reasonable suspicion the person has committed a crime, but to date, the Supreme Court has not extended this to DNA sampling unless they consent. Now, if they're under arrest and they commit a felony, depending upon what state you're in, yes, then they are required to submit to a DNA test. So real evidence, what does that really mean? So kind of an introduction. In Chapter 4, we defined real evidence, remember? To include anything that can be perceived with the 5 senses except trial testimony. And this includes physical items and documents, exhibits, and pictures. And since this is such a broad category, evidence will be divided into 2 chapters, or kind of 2 areas. Evidence discovered at the scene of the crime and during the follow-up investigation, scientific evidence, and experiments are going to be discussed in this chapter. So all types of real evidence have 2 things in common. They must be marked, and they must be formally introduced into evidence. And the attorney who wishes to introduce them must lay that foundation, if you will, like we talked about before, to establish the admissibility of the item in question. And the formal process of marking evidence has 4 steps, and it could be a little bit different from department to department, and maybe even state to state, but for the most part it's going to go like we're going to talk about. So first, the item must be shown to opposing counsel before testimony about it is introduced. Now, this gives the attorney a chance to see what it is to be discussed and form appropriate questions. Second, the side that intends to introduce the item has the court clerk assign it a number or a letter for identification purposes. And then third, witnesses must be called to, remember, lay the foundation necessary to show that each item is admissible. It's relevant and we need it. And then last, a formal request is made to admit the item into evidence. And if the judge rules the item is admissible, it is given that exhibit number or letter, and it becomes evidence in the case. And if you look at your book on page 180, there's an example that illustrates the process involved for the prosecution to, let's say, introduce a murder weapon. So again, you can look at page 180. Now laying a foundation, remember, it establishes how the evidence relates to the case, establishes how witnesses related to the evidence. It exhibits that have been admitted into evidence may be examined by the jury and can usually be taken into the jury room as well during deliberation. So this is part of laying the foundation. Now, I'll kind of read through this one example, and then I'm going to have you look at the other examples yourself in the book. So the prosecutor might show the gun to the attorney. And the prosecutor might say, Your Honor, the prosecution requests that the clerk mark this .38 caliber Smith & Wesson revolver for identification as People's number 1. The gun is given to the clerk, who attaches a tag to the gun with People's 1 written on it. Now the prosecutor will call witnesses and lay the foundation to show that the gun is the one found at the crime scene, and that ballistic tests show that the slug test fired from the gun matches the slug removed from the person's body. Now, defense cross-examines and raises objections, if you will, to the admission of the gun into evidence. Then the prosecutor will say something like, Your Honor, the prosecution requests that the gun, which was marked as for identification as People 1, be admitted into evidence as Exhibit 1, or just admitted into evidence. And the defense may make an objection, and then the judge will rule on the objection and allows evidence if no objection, or if the objection is overruled. And he might say, let the gun be received into evidence as Exhibit number 1. And that's typically how it goes. And again, exhibits that have been admitted into evidence may also be examined by the jury, and for the most part, these things can be taken into the jury room, excuse me, and examined further by those jurors as they contemplate the guilt or innocence of an individual. So here's kind of an example slide I threw in for you of what I just read that talks about the examples of introduction into evidence. So you can take a look at that. Now, as it relates to crime scene evidence, all items that are admitted as exhibits must be authenticated, which means shown to be genuine. And to authenticate evidence found at the crime scene or during other parts of the investigation of the case, it is necessary to show that the item is the same one described by the witness. Now that makes sense, right? And it needs to be in the same condition that it was at the time it was found by the police, unless it was necessary, of course, to conduct some type of laboratory test on it. And if tests have altered its appearance, this must also be explained to the jury. And careful handling of evidence and accurate report writing are crucial in this particular situation. So, and there are different ways to package different things, and we'll spend some time possibly talking about that at the end of the chapter. So again, all items that are admitted as exhibits have to be authenticated, which means we have to show they're the same one. And typically, unless there's a test done on it, we need to bring it or show it or authenticate it, and it needs to be in that same condition at the time that it was located by whoever it was located by. Now, it is very important to protect evidence so that it is not destroyed or damaged. And with that, restricting access to the area prevents people from stepping on evidence or handling it or removing it from the scene. Now, no one should be allowed to try to clean up the area before the investigation is completed because, of course, evidence could be destroyed. And it's much better to have many items gathered up and put into evidence or the evidence locker that may not need to be used than to discover that something that was needed was left at the crime scene or in fact not collected. So when we talk about processing the crime scene, the first step in laying the foundation for the admission of crime scene evidence, again, is to have someone identify the object, and testify about where the item was found. And they must typically record its precise location and where it was stored at. So again, the first step in laying the foundation for crime scene evidence is to have someone identify the object and testify about where it was found. Now, before collecting and packaging this evidence, the officer should make a detailed record of the crime scene with a clear indication of where things were found. And this can be done by sketching the location and making detailed notes, or taking pictures, or doing all of those. And ideally, all three of those will typically be done. Now, on page 182 would be an example of laying the foundation for evidence that was found at the crime scene. And on page 183 would be an actual picture of a sketch, which would be kind of an example. So here's the information on 182. And again, so I'll go through this one with you, and then future ones we'll have to kind of let you read. So when we talk about laying the foundation for admission of crime scene evidence, so let's go through it. The prosecutor: did you search the defendant after you arrested him? Officer: yes, I did. Well, prosecutor, what did you find? Well, he had a gun in his waistband and 6 loose bullets in his pocket. Prosecutor: is this the gun that you removed from his waistband? Officer: yes, this is the gun that I took from the defendant's waistband at the time of arrest. Prosecutor: how can you tell? Officer: I copied the serial number before sending it to the evidence locker. I just looked at the serial number and it's the same one. So this is one way to show that, hey, this is the same thing that I found out at the crime scene. So hopefully that kind of makes a little bit of sense. And then here's the diagram that you'll see on page 183 that shows the homicide crime scene, the sketch, if you will. And some of these sketches can be computerized, and they have really cool computerized CAD programs. And some are a little bit less technical, if you will. Or you could just hand sketch it as well, or you could take notes and pictures. But here you can see the person, and then here's the legend down here, and they put the case number and all the information. So this is a sketch, if you will. Well, imagine this. This was the incident that occurred in the city of San Bernardino with the 2 terrorist suspects that ended up shooting and killing several people a little over a year ago. So imagine this kind of a crime scene that you would have to deal with, and how would you even record all of this information? Well, again, they have computerized sketching programs and different things to help do these kinds of very intricate, large-scale type sketches. So as part of the crime scene, we're going to talk just briefly on packaging evidence. And why do we do it, and why is it important? Well, the process of packaging evidence for storage is very, very important. And the evidence needs to be preserved for trial so that it won't be damaged, evaporate, or even be contaminated. And officers need to be aware of items that need special handling. For example, bloodstained clothes need to be air dried before packaging to avoid like mold growing on it or mildew, which would interfere with tests for blood type, etc. Now, each piece of evidence must be packaged individually. And it is useful to have a variety of clean envelopes and containers, of course, for various sizes for this purpose. Now, if you go back to this crime scene, yes, there's a lot of evidence there. Many shell casings, clothing, I mean, just all kinds of things. But at the end of the day, to avoid contamination, you are going to have to package things individually. And each container or envelope should be labeled so that it is not necessary to open it to find out what's inside. And you can look at these pictures of like evidence packages right here. Now there's all kinds of different shapes and sizes and bottles and things, and it'll have like the agency name. I'm looking right here, and the date it was collected and who collected it and a description of it and received all this stuff here. So you don't have to open it to figure out what's inside of it. So that makes it simple. That way there's less contamination or the probability of loss or things like that or damage. And again, this reduces the chance of losing or damaging evidence. And each piece of evidence should be marked or tagged because it may be removed from the envelope for examination at laboratory tests. So not only do you tag or you describe things here, but if there's, let's say, a firearm in here, you're going to have to tag something on the firearm, because what if you take it out of the envelope? So there's a lot of things to think of. Now, when an item is admitted into court, it is necessary to establish what we call the chain of custody. And this is so important. But before we get there, let me just kind of give you a little kind of review here. So the process of packaging evidence, and we've talked a little bit about evidence now, we know it's important, and we know that it needs to be preserved for trial so that it won't be damaged or evaporate, or the most important one, of course, is being contaminated. And when you're at your crime scene, the officer needs to be aware, or you need to be aware of special items that are out there, like blood-stained things or things that may need to be dried or put into airtight containers like liquid or something. So you have to know what you're going to need. And each piece of evidence needs to be packaged individually, remember? And why? As we sit here for just a second and ask yourself, well, why does it all have to be packaged separately? Well, to eliminate contamination. And that's one of the big things. And when items are, admitted into court, it's necessary to establish this thing called chain of custody. So each person who handled the item may need to testify in order to show the judge and jury that the evidence hasn't been tampered with, and who had it when, and maybe for what specific purpose. So it's very technical when you talk about it. Now, the modern forensic laboratory can perform a wide variety of tests and examinations, and forensic evidence can be used to establish the elements of the crime, conclusively associate the defendant with the crime, or help reconstruct the crime. Now, the Fourth Amendment here must be honored if specimens are sought from the suspect so that tests can be performed. So a person can be detained in the field based on what we call reasonable suspicion, but transporting someone to another location requires probable cause to arrest or consent. And this includes taking a person to an emergency room or other facility to obtain breath, blood, or even urine samples. Now, if there's no probable cause to arrest, it may be necessary to obtain a search warrant in order to obtain the samples needed for a specific test. And there are some people, as we talk about like crime scenes and what have you, that specialize in the collection of scientific evidence. And they specialize in a lot of the things we've been talking about. So here are some photos when we talk about crime scene units. Now, a lot of departments have these forensic technicians or crime scene technicians that will come out and pick up and package and sort and photograph and identify all of the evidence. Now, some small departments or smaller ones may not have this, and the larger ones tend to actually have this. So in some instances, an officer might be certified to do the crime scene photography and other things. So it could be an officer's job or a separate individual. And we'll look at the overview of a crime lab in just a few. And we'll talk about things that are in the crime lab and how they deal with that. So modern forensic laboratories can perform a wide variety of tests. And forensic evidence, like I said, can be used to establish the elements of the crime, conclusively associate the defendant with the crime, and or help reconstruct the crime. Now, I have a link to a YouTube video that I believe is to the Houston Police Department's crime scene laboratory, if you will. And it walks you through all the different components of their crime lab. So it's a little bit long. It's probably 40 minutes long, but it does walk you through, and it shows you what all of the different technicians do. Not necessarily how they pick things up in the field, but how they actually analyze the evidence once it's brought back to the lab. So I think you'll find that kind of cool and interesting. Now, when it comes to testing, typically law enforcement will make comparisons with samples from the defendant. And most common examples that we tend to run across are going to be fingerprints and blood. Now, some limits on some samples: absent an arrest, you usually need some type of court order or search warrant, if you will, to obtain a sample from a defendant. So, or you know, like I said, consent. So, absent an arrest, you're going to need probably a warrant or a court order, which is kind of like a search warrant, in order to take some type of sample from someone. And a more intrusive, or the more intrusive the test, the more likely a warrant would be required. Examples could be in a DUI case, or you're trying to get a blood sample and someone refuses to do that, and there are injuries in the case. You could get a search warrant actually to force a blood sample from an individual. So these are just some issues relating to scientific evidence. Now, cases that use scientific evidence provide greater certainty to the trier of fact and ultimately lead to more convictions. Now, you have to think about that. The trier of fact is who, if you remember? That would be the jury. So a lot of times the cases that use scientific evidence will provide that greater certainty to the trier of fact, which might equate to more convictions. And sometimes if the person is found guilty, it can typically result in longer sentences. So do we have to, when we talk about these tests that are used, do we have to lay a foundation for those? Well, the answer would be yes. So how do we lay the foundation for the introduction of scientific evidence? And that involves basically three critical questions. First, is the process a valid scientific test? Second, was accurate equipment used for the test? And third, did qualified experts perform the test in the proper manner? So the side offering the test has the burden of convincing the judge that it has scientific validity. And both sides may also stipulate to the validity of tests that are well established. Now, newer tests must be carefully explained to the judge, and this is done via questioning, or what they call voir dire, if you remember that phrase. And expert witnesses are called to provide the necessary background on the test and explain the scientific principles. And remember, we talked about those tests. How do we determine that a test is valid? Well, back in chapter 6, we talked about the Fry and Daubert case, which are used to determine if scientific evidence is admissible. The opposing side can also cross-examine and is also allowed to call its own expert. And after the experts have testified, the judge will decide whether the test results should be admitted at trial. And the factors considered include whether a theory or technique presents scientific knowledge that will assist the jury, whether it has been published in peer-reviewed professional journals, and the known or potential rate of errors, along with how widespread the acceptance of the test might be. And again, any test can be attacked on the basis of faulty equipment. So just kind of give you where we're at on laying the foundation. Now, on page 187, there's a table there that is a summary of procedures used when expert witnesses testify. And it's actually a pretty good chart for you to look at that you can follow, that'll help you kind of get through that issue of procedures used when expert witnesses testify in court. And then on page 188 is a table that shows introducing results of scientific tests. And it'll show you. So at the top, for an example, it'll say new lab test. And then it talks about the side that wants to introduce it, and then the side that wants to prevent its introduction. And it tells you what it is that you have to do. So again, kind of interesting and a good format to follow. But the last thing on where we're at here is, remember, judicial approval is required for admission. The judge has to say it's okay. So applying the law as it relates to this thing called the CSI effect. Now, recently, some prosecutors have complained that juries now expect scientific evidence like what you see on like TV shows. And the question is, does the public perception create kind of an unrealistic expectation? So because of all this TV, does the public think that we can do all this stuff that they do? And could this be avoided? And is it necessarily a bad thing? Because remember, in 45 minutes, it might be a 60-minute show, but when you put in commercials and everything else, people get a call, go somewhere, get a case, go investigate, interview witnesses, go to the hospital, collect evidence, interview more witnesses, follow up on leads, ID a suspect, track them down, get in a gunfight, arrest the suspect in like 45 minutes. And that's not the way that typically things go in the law enforcement realm. So again, you know, that CSI effect can be a big deal. Now, as we finish up with talking about tests, remember that, you know, there are things called testing errors, and tests can be denied, if you will, for different reasons. Evidence offered to show that equipment used in a test was improper or in a poor state of repair. evidence of human error in preparation, performance, or evaluation of the test. And then to show that the test in itself is unreliable, like maybe it has false positives or false negatives. And you could actually kind of equate this to, let's say, the polygraph, where, you know, it's not admissible in court because there's still some false positives and things like that, and it's not totally reliable. So that could be an example of these testing errors and perhaps why the polygraph hasn't been accepted as a valid scientific test. So what are some commonly accepted scientific tests? Well, many scientific tests are so well established that they are admitted at trial without a challenge to their validity. And this doesn't mean that the opposing side won't challenge the equipment used or the way the test was done. This section kind of discusses a little bit more the basis for accepting of the new, or the most common, scientific tests. Well, what are some commonly accepted tests? Well, how about fingerprints? Now, fingerprints were first used in New York courts in 1901. And the FBI created the first national database in 1924. So fingerprints remain an important tool for the police because they can be processed rapidly, and the test is relatively inexpensive. And extensive databases are available, which is really good. Now, fingerprint identification is based on three key principles. The fact that a fingerprint is an individual characteristic. The fact that a fingerprint remains unchanged during an individual's lifetime. And the fact that fingerprints have general ridge patterns that permit them to be systematically classified. So fingerprints have unique patterns allowing classification. And fingerprints from a crime scene must be compared to fingerprints that are on file. Those are called comparison prints. And some defense attorneys demand testimony about the procedure used to obtain the comparison prints. And it may also be necessary to establish the chain of custody even for the print card that might be on file. Now, fingerprints that are recovered at the crime scene or from other evidence are commonly called latent prints, or what we call, they're not developed prints. So these are prints that are recovered from a surface. And detailed testimony about how the latent prints were recovered is usually required in trials, and investigators have to be aware of other laboratory tests that may be needed in the case, because fingerprint powder or other substances used to develop prints may interfere with another test that has to be performed as well. The traditional method, however, of obtaining prints on a hard, let's say non-absorbent or non-porous type surface like mirrors, glass, and smooth painted surfaces was to apply fingerprint powder to the surface with a brush, and typically the good ones were made out of like camel hair. And the fingerprints appear when the powder adheres to the skin oils from the fingers. And then they are photographed, and then they are preserved by lifting, if you will, that's the term, the print from the surface with a special adhesive tape that's made for the purpose. So you have the print dusted with the powder, and you put the tape over the top, and you slowly pull it up, and you can see the powder that has adhered to the tape, and then you put the tape on a white background, and the powder is dark, and you'll be able to see the print, and the prints look like what's on the screen in front of you. Maybe not as good, but you'll see a fingerprint typically like this. Now, without going into it, because this isn't a fingerprint class, there are typically 6 common patterns. And if you want, you can ink pad one of your fingers and you can roll them on like a piece of paper, like a copier paper or something, and you can then compare it to the chart here and see which one of these you might be. So that might be kind of cool to do. And again, here's what latent prints look like. So you dust them with the powder, and then you use the tape to pull the fingerprints up. And sometimes if you're lifting prints from, let's say, a dark background, you may want to use what they have. They have like different colors of fluorescent powder to help those prints stand out. So there are different ways to lift fingerprints, and this is kind of cool. So how do we apply the law to fingerprints? Well, fingerprints are matched depending on how many points between the samples are identical. And most departments use experts, but recent tests have been questioned on how good humans are at matching prints, and actually they're very good. So should matching be left to machines? And when is a match good enough? And again, we're not going to take the time to talk about how many points constitute a good match, and perhaps we'll get into that in another chapter. Well, never mind, I gave you the answer anyway. I forgot I stuck this in here. So the typical print has 150 ridge characteristics. These are you can see them because when the powder raises the ridges. And experts say you need about 8 to 16 to make a match. Now, computerization has helped a lot as it relates to getting the initial match on an individual. And then the human eye of a fingerprint expert can confirm what the machine or the computer has already done. So there still are fingerprint expert or fingerprint comparison individuals out there. Well, what about blood alcohol? Let's talk briefly about that. Well, the most common use of blood alcohol testing is when it's used in drinking and driving cases. And many states use the 0.08 level as conclusive evidence of driving under the influence. And a lower standard frequently applies to juveniles. For California, it's 0.08 or 0.08, either one. And evidence of blood alcohol may also be used in cases in which the defendant's sobriety has a bearing on their criminal intent. So kind of think of that. And alcohol is rapidly absorbed into the blood and circulatory system from the stomach and small intestine. And absorption is more rapid if there's no food in the stomach. So one test that's typically used would be what you see in front of you. This is kind of like a PAS device. So the most common test for alcohol is done with like breath samples. Blood alcohol tests are also common, and they also have urine tests. Now, blood samples should be taken, of course, by qualified medical personnel, a doctor, nurse, or a phlebotomist. And special procedures are required, such as cleansing the skin with alcohol-free disinfectant before taking the sample. And of course, the chain of custody for blood or any other type of sample must be recorded. Having an officer witness the taking of the blood eliminates the need for the person who actually drew the blood to have to testify in court if the case, in fact, goes to trial. Because otherwise, the technician who performed the lab test would have to testify, or who drew the blood would have to testify. Now, once that blood is sent to the lab, the person that actually performs the analysis of the blood, yes, they could be called to come to testify. But if you're there when the blood is taken, you can testify on behalf of the, let's say, phlebotomist. And the device you see on the screen is what we call a PAS device, and it's typically an initial test that's given in the field to determine someone's blood alcohol content. And then when you take them back to the station, there is there's a machine that you use, typically called an intoxilizer, without getting into too much detail. That's a larger machine, which is what you will use to actually conduct the final breath test. So hopefully that kind of clears up the breath. Now, what about blood typing? Well, there are many questions that forensic serologists can help to answer. And first would be, is it blood? And if so, is it human blood? And if so, what group does it belong to? So blood typing it's a quick and an inexpensive way to eliminate a person as a suspect if a person's blood type is not the same as the blood found at the crime scene. And the typical types would be A, B, O, or AB, and positive or negative, and we're not going to go into all the hoopla. And alternative is based on an RH factor, and there are 8 different types, and again, we're not going to kind of go through all that. And a second alternative would be based on an MN system, and there are 9 categories. But tests can be formed on stains to determine if they are human blood. And for example, when luminol is sprayed on an area, traces of human blood emit a blue glow that can be seen in a darkened room for about 30 to 45 seconds. So those are some things that we can think about. Now, a stain is swabbed with cotton as well, which can then be sprayed with ethanol, and that basically reacts with the hemoglobin in the blood, and if there's no color change, then peroxide is added, and when blood is present, then a pink color appears within a few seconds. So you can see the different tests, but we're just typically talking right now about blood typing. So the important issue here is to determine if it is blood, and if it is, what type, so you can match that type to perhaps your possible suspect. And here's an example of luminol testing, to where you can spray the luminol substance onto a surface, and you'll be able to see if there's blood patterns or blood there. It will glow because the luminol will react with the iron in an individual's blood. And I'm not going to go into super detail because it's just it can be a little bit complicated, but this is what it would actually look like in a darkened room. So what about DNA? This is a big one. So identical DNA molecules are found in each cell of a person's body. Now, with the exception of identical twins, each individual's DNA is unique. And tests vary on how complex and how expensive the DNA test could actually be. And the first practical DNA test, the application, were created in about 1985. Now, due to the uniformity of DNA throughout the body, a semen sample, let's say, found at a crime scene can be matched to a blood sample taken at a clinical laboratory or a cheek swab obtained at a police station. And DNA evidence is now admissible in all states. But each time a new type of test for DNA is developed, it must be established that the results, again, are scientifically valid, right? Now, laboratory tests to match DNA samples can be very complex, and we're not going to really discuss all of those details. One of the tests that have been completed, or I'm sorry, once the tests have been completed, the matching is done both by visual inspection and by computer matching. And the complete results of the test are typically referred to as a DNA profile. Now, while DNA is used a lot of times to place a person at the crime scene in order to get a conviction, It has also been used several times to establish that a person didn't commit the crime. And a group called the Innocence Project, which has many local affiliates, has utilized DNA tests to obtain the reversal of more than 300 convictions since about 1989. Now, there are 5 types of DNA testing that are discussed in your textbook. And keep in mind that time, money, and availability of DNA laboratories restrict the number of samples that can be tested. Now, for this reason, a lot of agencies have severe backlogs for DNA testing, specifically in the processing of rape kits and DNA from other crime scenes. Now, I'm going to let you go through these different ones. They're on page 192 and they're on the slides. And some of them are extremely difficult to even pronounce. So I believe I made little acronyms. So the first one is the RFLP. And then you have the STR. So as we kind of go through these, and again, I'm not going to go through all of them. You have mtDNA. And you have something simple, the Y chromosome analysis, so that kind of makes it easy. And then, of course, you have familial DNA, which is one part of DNA processing that you saw in that case study that we did on the Grim Sleeper, that case that we saw at the very beginning. So read a little bit more on familial DNA. And it's an awesome way, but a controversial way. And this is what a DNA profile kind of looks like. So you can look at the crime scene. So if you look on the left, DNA stripped from the crime scene, and then the suspects 1, 2, or 3. Well, you can look and you can match up those areas to see who you believe the suspect might be. And then the same on the right. And every year, just so you know, and you'll be a part of this as well, at the end of every semester, we do a DNA lab at the college where you're going to get to come in and actually process DNA. I mean, really. And you're going to develop a DNA profile. So if you look on the right here, that's a DNA profile. And I'll announce that. And just because you're at an online class doesn't mean that you can't attend. So last year we had students that showed up and did this DNA class, and it was actually kind of awesome. So some other commonly accepted tests would be identification of controlled substances. So samples are screened to provide general type like opiates and things like that. And police use representative samples for more detailed tests to distinguish type of opiate or source. And again, there are different tests that go along with it. So in cases involving possession, distribution, manufacturing of controlled substances, laboratory analysis is crucial. Testing for controlled substances is essentially qualitative and quantitative organic chemical analysis. And as the number of drug cases has increased, the demand on the forensic laboratory, new techniques have been developed to do the job a little bit faster and more accurately. So there are different ways to do it. And some of the common tests are what they call the infrared spectrophotometry, and that's a tough word to say. There are spot tests and microscopic tests, and you can get a little bit more in depth in your textbook. There are even what they call presumptive tests like these. And these are test kits that as an officer you would take in the field, and if you arrested someone with suspected, in this instance, cocaine, you would just take a little sample and you would put it into this plastic container, if you will, and inside of the container you can see here there are like little ampules of different liquids, and you will pop them say from left to right or right to left, whichever way that you are told to do it. And as the color comes up, it will tell you what it is. So cocaine would be blue on the bottom and the pink on the top. Well, this in fact is a cocaine test kit, and it tested positive in this instance for cocaine. So these are field test kits. Now you will still book the drugs, send them to the forensic laboratory, and they will do a further analysis to confirm your field test. So kind of cool. Identification of firearms. Firearms can be identified from their fired bullets and cartridges, and the firearm examiner is commonly referred to as a ballistics expert, even though technically ballistics refers to the motion of projectiles rather than matching the expelled object of the weapon. So a firearm examiner, again, is often called a ballistic expert, and the comparison of bullets and firearms started back in 1906, and it became widely accepted by the 1930s. And there can be problems given the condition of, the recovered bullet from a firearm. And typically, though, tests focus on what we call the lands and grooves. And those are the kind of the inside of the bullet, there'll be the lands and the grooves. And they might use what we call a comparison microscope to take two different, say, casings, bullets or what have you, or a firearm and a shell casing or a bullet, and compare what we call the striations here. So they will use this comparison microscope in order to do that. Now handguns, rifles, assault rifles, machine guns, they're what we call rifled firearms. And their barrels have these spiraling, like I talked about, lands and grooves that leave patterns of parallel scratches called striations on the projectile. Now shotguns, on the other hand, they have a smooth barrel inside and they don't have striations. So that bullet, when it comes out of a handgun or some of the guns that I just described, it actually spins, it turns, because inside there are lands and grooves. And when it comes out, the bullet's going to have these marks on it, these striations. And an examiner can take this comparison microscope and they can put a sample of evidence here, a sample of evidence here, and look at these side by side to see if they're the same. And you can kind of look here and make your own determination. So that's the kind of with firearms. And then there's some other scientific experts and tests. And how do experts come into play? Well, they may need to testify about forensic, like anthology or anthropology, and age progression, and say geographic profiling, and all of these different things. You may need experts to come in and talk about the different things that forensic footwear analysis, digital imaging processing, forensic accounting, computer or digital forensics. And these are all the different kinds of tests or experts that people can testify about. So let's just take the footwear one. Scientists use footprints to show the height and weight and even impairments of individuals. And somebody could actually come in and testify about that. And then some tests that are not commonly accepted would be things like, we talked about polygraphs. Tests that attempt to detect deception based on skin or heart rate and breath rates and perspiration on your skin. And the skill of the operator in a polygraph is critical, but sometimes the results are often inconclusive, so they're not an accepted scientific test. And the same with like hypnosis. Putting somebody under hypnosis to refresh their memory. And again, one problem here is that the subject may be subject, if you will, to suggestions or things like that. So these are a couple of tests that are not commonly accepted. And if you've ever had a polygraph, this is kind of what it looks like. And then a court case that kind of talks about the reliability of polygraphs. So United States versus Sheffer. The Supreme Court heard a case about the scientific reliability of polygraphs, and the defendant sought to admit this test into a military trial. Now, under military law, polygraphs are per se inadmissible. The defendant claimed that this violated the Constitution. Now, the Supreme Court ruled it is up to the individual states to establish the validity of a polygraph and that the defendant's trial was not unconstitutional. So this case basically says, remember how we talked about how states can set the rule of evidence? And that was in a different chapter. Well, here's an example of that. Like for California, polygraphs are not admissible. So most police departments use polygraphs in hiring new employees. And we know polygraphs are not admissible in court cases because they're sometimes inaccurate. Well, why then can we use them for employment? And why or should they be used to investigate crimes? And then finally, experiments. Now, the ideal experiment screens out all extraneous variables so that the experimenter can measure the impact of one factor. Although there are numerous situations that lend themselves to experiments in criminal trials, few experiments are actually introduced in court. And this is largely due to the attorney's lack of knowledge in this area. Now, some experiments are quite simple, such as going to the crime scene under lighting conditions that are similar to those that existed at the time of a crime to determine if a stop sign is visible, or having someone walk from one location to another to actually determine if it is possible to cover the distance in the time stated by the defendant. And others are very complex and require expensive equipment like microscopes or x-rays. So experiments should eliminate all possible variables. Tests then change one variable and measure result. Now, the basic concepts, again, are valid experiments need similar circumstances repeated for each test. And the test must have a basis in sound science, and the test must conform to established standards. And all the standards for things like this, again, are found under the FRE, those Federal Rules of Evidence. So the FRE and some states sometimes, though, do not distinguish between experiments and other types of evidence. And when that happens, the normal rules of relevance are used to judge admissibility. But there are some experiments that can be used. And here's the case of Kumho Tire Company versus Carmichael. And I'll let you kind of read through that one. So the procedure to bring experiments into evidence, to admit them. Well, first, you have to call a party who performed the experiment, and second, you have to lay that foundation. And this is like anything else, even new scientific tests. Third, you ask the witness for the report on the results. And under the foundation, the expert must be familiar with the facts, must have knowledge of the equipment, must compare the facts with the results, and the judge must accept that it is in fact an accurate test. And some common admissions could be like time of death or speed of cars. So a lot of things that we covered in what I would say would be kind of quickly in a time frame that we really could have spent a little bit more time on it. But that's where, again, it's incumbent that you go back through the textbook and look at some of the examples that are listed in your textbook to help you, since we just kind of touched on a few different things as we went through the chapter. So with that being said, this will conclude our lecture on Chapter 7. If you have any questions feel free to post them on the discussion board or send me an email if you don't want to post them on the discussion board, and then don't forget about your student resources as well. So with that, again, until next